to avoid impropriety and the appearance of impropriety. And if you believe there's any conflict that you have that presents itself, you may tell us now, or you may discuss that when the issue actually comes up if you think there's a problem. But if I don't hear any, we will proceed to begin our meeting. Okay. We are now live streaming, I noticed, so be alert to that, everyone. Excuse me. And I think we'll go ahead and get started. It is 5 after 3, and Catherine can join us if she's available. But Nicole, why don't you give us sort of a recap of where we are? I hope everyone got Nicole's materials this morning. I mean, she sent them out again this morning, but they were sent out, of course, a couple of weeks ago for us to look at. This is the inquiry dealing with the use of a public adjuster and a contingent fee arrangement between a homeowner and a public adjuster. So, Nicole, what do you want to tell us about this inquiry?
So this came from Mr. Neil Whitford, who is asking about whether or not he can participate in calling a public adjuster as an expert witness when the public adjuster and the client have entered into a separate fee arrangement in which the client had agreed to pay the public adjuster a percentage of any settlement that the client would receive. This opinion is governed by Rule 3.4b, which generally prohibits a lawyer from paying an expert witness a contingency fee. And so that's what the language is in the rule. However, the contract between the public adjuster and the client is not really governed by our rules. So we just need to look at whether or not the lawyer can acquiesce in pay or allowing calling that witness when they know that the witness is going to be paid a contingency fee. Some states have prohibited a lawyer participating in using a witness who's being paid a contingency fee, and they say that it's against public policy. But in those other states, their rules also includes language that the lawyer cannot pay an expert a contingency fee, but also cannot acquiesce in the payment of a contingency fee to an expert. North Carolina's Rule 3.4b used to have that language, but it was removed from the rules years ago, I believe before 1997. So currently we don't have that, and also acquiesce or a prohibition against acquiescing in the payment of a contingency fee. There is a statute, North Carolina General Statute 58-33A-60D, that appears to permit a public adjuster to receive a percentage of the proceeds so long as it does not exceed 10%. So my interpretation of that was that the expert could receive a contingency fee. And since the contingency fee is allowed by law, then our rules wouldn't prohibit a lawyer from participating. Suzanne had a little bit of a different interpretation of the statute, and she's not sure that it means that the person can be paid a contingency fee. So you all know that the Ethics Committee cannot give a legal opinion and interpret a statute, but I think us as a group, we can look at whether or not we think there is an issue there, and then figure out what the opinion should say. So the opinion currently says that because the statute permits the client to pay the public adjuster contingency fee, then the lawyer is not offering or giving an inducement to a contingency fee that is prohibited by law. So I recommended a subcommittee because I'm not sure about the statute.
Can you, I don't know whether you have this capability or not from where you are, Nicole, can you put the statute up? Can you share screen and put the statute up for us?
Let me see.
Again, Nicole is, of course, absolutely right. We are not in the business of opining with respect to the interpretation of statutes, but I think it would be helpful for us to see what our legislature has said is the public policy of North Carolina with respect to contingent fees.
Just give me a second. Let me just pull up the statute.
Our the opinion is correct, and Nicole, in the opinion as it's drafted, is correct in that our obligation is, of course, to regulate lawyer conduct. And the question is, by putting on the, by calling this person as a witness, are we somehow creating an inducement where the lawyer is creating an inducement for the witness, which is a violation of the rules? That's at least how I understand it.
Okay, so can you see my screen?
Yes.
Yeah.
You see the statute? After you all have read it, maybe I'll read it so that Stuart,
Yes.
she's driving, so she can't read.
Excellent idea, Nicole. Thank you. Go ahead.
Okay, so 58-33A-60 Public Adjuster Fees, Part D. In the event of a catastrophic incident, there shall be limits on catastrophic fees. No public adjuster shall charge, agree to, or accept as compensation or reimbursement any payment, commission, fee, or other thing of value equal to more than 10% of any insurance settlement or proceeds. No public adjuster shall require, demand, or accept any fee, retainer, compensation, deposit, or other thing of value before settlement of a claim.
So this is Stuart. I'll just jump in. I've handled a case before when a public adjuster has been involved, and so I'm somewhat familiar with that. There was a contingent fee in that case. I've always understood that that was allowed, and so, you know, I know we're not supposed to interpret the statute, but when I hear that, that doesn't make me change my mind on that, for what that's worth. And when this came up in the ethics meeting, the general ethics meeting, my initial thought was, yes, this should be allowed, but of course, you know, the insurance company should be allowed to also tell the jury or the judge or whoever that this is the fee arrangement and cross-examine on that.
Yep.
Jack here. I'm sorry. Did I interrupt, David?
No, go ahead.
I absolutely agree with Stuart, and I would just add, you know, a nuance to what Stuart's saying is that in my experience, one of the things that falls under my consumer advocacy is disaster relief litigation. And so what happens that I've seen, and the way I like the way this statute is set up, is it limits the amount of money an adjuster can make, and it ties the adjuster being paid to an ultimate settlement of the claim, and enables people who can't go out and get an objective opinion to be able to get an objective opinion. For example, old Mrs. McGillicuddy has a tree fall through her roof during a disaster. Is that particular wind, quote unquote, event covered under a policy? And the insurance company ultimately, maybe in this case, you know, this is a hypothetical, but the insurance company says, no, under X, Y, and Z portions of your insurance contract, that event was not covered, blah, 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 blah. However, the public adjuster, who the homeowner can then utilize to get an objective opinion and have it in a way that they don't have to pay. Obviously, my clients can't pay for private adjusters to go out and do that. It enables them to acquire the evidence that they would need to counter the denial of their claim. And now, to the point here, is if you couldn't use them then as an expert witness, then you'd be putting them back in the position of having to hire another private adjuster to, or expert to counter what the insurance companies said. So, and I know that's a public policy argument, and I know it's probably outside the bounds of what we're supposed to be viewing. But I will just tell you, in my world, this is a great tool, and it wouldn't be such a great tool if you then had to go out and rehire a person because you couldn't use their testimony in their report. But now, more specifically, and then I'll shut up. I think that the point that I liked in what Nicole wrote was that clearly this is a carve out and wasn't intended under the rules of ethics to be a no-no anyway. So I would say, without all the public policy nonsense that I just spewed, because I felt that David needed a lot of hot air without, being in a conditional air conditionless circumstances. But I like it. I like the way Nicole wrote it, and I think it is a properly carved out area. So I'll shut up.
Well, I agree with that too. And looking at Rule 3.4, it just says you can't offer an inducement to a witness that is prohibited by law. Obviously, they're able to get it. I mean, we can't give it to them, but if they've made that arrangement, and Jack, I agree with your point on that. I mean, that's the reason the public adjuster is there, to counteract the adjusters that are with the insurance companies that are getting paid very well with the insurance companies.
Yes.
Yeah, I think that's correct. I don't see, I think a reference to this statute is probably correct in the opinion, in that if the if the contingent fee, a contract was in violation of the statute and the lawyer put the man or woman on the stand, and that resulted in a violation of the statute, that's something that the lawyer shouldn't be involved in. But otherwise, I think it's basis, as Stuart said, for cross-examination. It's like, I don't know how many times, never me, of course, but I've had lawyers ask questions about how much an expert was getting paid, and the exorbitant rates that some people pay their lawyers, pay their experts, whereas most of my experts just work for free because they're fighting on the side of right, truth, justice, American flag, and apple pie. So, I think, to me, I think that we've gotten the thing right. And it looks like this is, as you said, Nicole, not regulating lawyer conduct. I mean, this is lawyer conduct that is not regulated by the state bar, but there's nothing here that could involve the lawyer in violating the statute. I do think the reference to the statute is proper, but otherwise, I think this is fine.
Yeah.
That appears to be the consensus. Nicole, do you have questions about that?
I do not. So now I think what you just all are in agreement that we will, or you will recommend publication.
That would be Jack's motion.
Like to do?
Yes, thank you. Mary seconded it.
I move.
Make it, and Jack will second it. That's fine. We'll keep Stuart's hands on at 10 and 2. Any further discussion? If not, all those in favor, please say aye.
Aye.
Okay, great. Thank you. Unless y'all all want to watch Stuart drive to wherever she's driving.
This has to be the single shortest subcommittee I have ever been on.
Please, Jack,
remember,
David,
we had one last year, and I think it lasted like maybe 15 minutes.
Okay. Well, we got started late.
The one where I chaired for 7
Well, we
and a
didn't get
half
started
minutes.
until about 5 after. So
Yeah.
Thank you, Mary. That's correct. We didn't. So let's shut up and we'll get out of here at 3:19. That's only
Okay.
15, and we can break the record.
All right. Thank you, everybody.
And
Thanks,
folks,
y'all.
would everybody be at, I know it's a long drive. Maybe that's where Stuart's driving. She's already started driving to Wilmington, to the Ballard Hotel. But otherwise, I hope to see all of you in next month at the quarterly meeting.
I'll be
And
there.
unfortunately, I will not be able to be there, but feel free to tell everybody that I agree 100% with whatever all of y'all say.
you better be
Well,
careful
cherish
about
that
that.
part. I've never been told that by another lawyer, a woman, or you. So that's all of that's fine. So that's great.
All right. Thanks, y'all.
All
Thanks,
right.
guys.
Thanks.
Bye-bye.
Bye.
Thank you, Nicole.
You're welcome.
Thanks,
Bye-bye.
Nicole.
Thank you,
Bye.
Nicole. Thank